Good morning, everyone. Thanks very much for joining us on day 2 of Insolvency Week by St Philip's Chambers. Today we have Iqbal Mohammed, and he's going to be talking to us with an update on personal insolvency issues and cases that have come up in that area. If during the webinar you have any questions, pop them in the Q&A box below and we'll ask them of Iqbal after he's done his presentation. So I'll hand you over to Iqbal Mohammed and his update on personal insolvency. Iqbal.
Morning, everyone. I'm just going to get my slides up, so if you bear with me. Right, okay, I'm hoping everybody can see that, unless Marc tells me otherwise. Great. Right, so thank you very much. I'm going to talk to you about recent cases and an issue, rather than issues, but an issue certainly, concerning personal insolvency. There's not been many reported authorities in the last, say, 12 to 14 months, for obvious reasons, because of the coronavirus. But there are some reported cases that I think are worth having a look at and examining in some detail. Before I do that, though, I want to talk to you about the coronavirus because of COVID. There's obviously been a number of legislative schemes that have been passed to protect companies, particularly commercial tenants, from the adverse effects of the coronavirus. And one of the things that we should be aware of is the personal liability for debt. At the moment, SEGA provides for a moratorium when it comes to the winding up of companies based on a statutory demand concerning arrears of rent. Section 82 also provides you with, in effect, a moratorium on peaceable re-entry, so landlords can't use that route of recovering possession of property. Obviously, Section 82 only applies to arrears of rent. It doesn't apply to, for example, other breaches of covenant. One of the things that I've dealt with recently on a couple of occasions is what can best be described as a lacuna in the law, which is where the leasehold is held by the tenant personally. And for example, the restaurant or the business is occupied and is traded through a company. The company has the benefit of the protection of Section 82, but the landlord does not have the protection of either SEGA, because he's not a company, or Section 82, because the issue of a statutory demand has nothing to do with the retaking of possession, even though that might be an indirect way of obtaining possession following the bankruptcy of the tenant. So there are a number of cases I've dealt with where a commercial tenant has been served a statutory demand or a bankruptcy petition, and actually the options for them in terms of contesting that is very, very limited. Certainly there is nothing under the Coronavirus Act or under SEGA that would allow them to take issue with the presentation of a petition against them for bankruptcy. So in that context, and that's just one example, I think it's quite important to make you aware of the debt respite scheme, also known as the breathing space scheme, which has been published in terms of the regulations by the government and comes into force on the 4th of May. I'm not going to go through the whole scheme with you. It's frightfully dull, but there is a really helpful guidance published by Her Majesty's Government on their website on .gov.uk, and it really explains the scope of the scheme, the ambit of the scheme, how it's supposed to operate. And I'm just going to go through some of the key features in terms of personal insolvency and debt recovery that we may be interested in. The first is that it comes into force on the 4th of May. So potentially at the moment, it's not really relevant if you have a petition pending for hearing before then, or if you are served a statutory demand. But I'm going to come on to that. Secondly, it covers qualifying debts. And for most intents and purposes, your average debt where you're concerned with either rent arrears or mortgage arrears or things like that would be covered. There are some exceptions. They're set out in the guidance and also in the regulations. They're very, very difficult to discern from the regulations, but much more easy from the guidance because they're in bullet point form. But in essence, the debt has to be a qualifying debt, and usually it would be a qualifying debt vis-a-vis personal liability to repay. The effect of entering into the debt respite scheme, it provides for a stay of any enforcement of that debt, which includes bankruptcy proceedings. What happens in broad summary is that the debtor has to apply for the scheme through an agent, which is usually an IP, is an insolvency practitioner, or could be some other person, for example, a debt specialist. Once they are on the scheme through this agent, a notice is then served on the court and on any creditors to say that they are part of the scheme, and the creditor is then obliged to withhold enforcement or to stay enforcement. The tribunals and the courts are themselves obliged to stay the enforcement of the debt pending the conclusion of the scheme. The key thing with the scheme is that you can only operate it once every 12 months. So it's a case of having enough debt to be concerned with to then activate the rights that you've got under the scheme for a breathing space. Obviously the clues in the title, it's a breathing space. It's effectively designed to buy you time as opposed to wipe away or erase the debt. Now, I did say that it came into force on the 4th of May. Now, in my view, this is not necessarily a problem at this stage because of a couple of cases. Probably the most important one is a company injunction to restrain winding up petition. There's also another case called the Travelodge and Prime Aesthetics Limited. In these two cases, and nobody contacts me at all, ever. Nobody ever knocks on my door, and I do a seminar at 9:30 in the morning and look, somebody's at the door. Just bear with me a second. You could probably make out the footsteps of my lovely wife rushing up the stairs to answer the door. It's probably the only time she does anything for me, to be honest. I have to roll on an insolvency seminar to have that kind of treatment at home. Thank you. And it's a parcel for her, not even for me. As I was saying, in a company and in Travelodge, what happened there was just before either SIGA or Section 82 came into force, the courts granted an injunction to restrain the presentation of winding up petition. Forgive me, on both occasions it was actually the coming into force of SIGA. And even though SIGA was not law, it was not in force, there was no right to any of the provisions that provide for a stay or a respite under the SIGA, under the Corporate Insolvency and Governance Act. The courts granted the injunctions to restrain the presentation of the petitions on the basis of impending legislative change. And there's actually some authority for that going back to the 70s concerning unfair dismissal rights. So there is actually authority and there is actually some jurisdiction when it comes to the High Court to grant relief, bearing in mind impending legislative change. That's been done in the employment jurisdiction, and it's also been done in the insolvency jurisdiction with SIGA in these two cases. And the great thing about RIA Company is that because it's not, the topic is not raised very much, the judge or counsel rather before the judge argued all of the points that we need to be aware of as practitioners, and it's all set out in the authority for you. In a very recent case, the last week in fact, we were about to make this very argument when it came to the debt respite scheme on the hearing, the first hearing of a bankruptcy petition when it came to a client of ours who was a commercial tenant. So I was fairly confident that the judge would grant an adjournment to the first week past the 4th of May for him to participate in the scheme. And I was fairly confident of that, but it didn't actually get there because I managed to persuade the judge to order a reservice and amendment of the petition on a completely different ground. But it seems to me that that's something that we should be looking at when it comes to at least commercial tenants, but perhaps even other debtors who are facing bankruptcy petitions before the 4th of May. Right, now moving on then to recent cases. The first one is the case of Jagdeep Singh Wasu, reported Edwards and Aurora 2021. This is a case that concerns void dispositions under section 284, and it's the only authority really dealing with the issue of value. Just to remind you, When it comes to Section 284, unlike its corporate insolvency equivalent, there's a provision that provides there will be no remedy in respect of any property or payment which was received before the commencement of the bankruptcy, providing that it was in good faith, number one, for value, number two, and without notice, number three. So if you like, that's the defence for the recipient that's provided for in statute, providing that they can meet the three conditions set out for it. Now, in the case of Wasu, the good faith and the without notice was conceded by the trustee in bankruptcy, so they are not helpful to us on those 2 points. But it deals with value in some detail, and it's a very good authority that looks at what for value means when it comes to Section 284. And there was argument that it's the same meaning as, for example, transactions under value. But the judge, as I'll go on to explain, did not accept that, and held that the meaning in Section 284 is more literal than in other provisions provided for in the Act. So the facts, we have the bankrupt, and we have the Wasu Medical Centre, which was a partnership established by his parents. Wasu at this stage was I think the correct word is struck off, but maybe deletion or erased, whatever the correct technical word is, was a struck off dentist. And his parents set up a partnership called the Wasu Medical Centre. They traded through a company of which the bankrupt had an interest of about a third. They met a landlord and entered into a lease through the partnership to occupy some commercial premises in London. They needed some dental equipment, which is obviously quite expensive, about £250,000, and they decided to fund that through Aurora, which was a leasing company. Aurora effectively would buy the equipment and then lease it to Wasu Medical Centre in return for the payments of a monthly rent for a period of 36 months. Perfectly standard when it comes to equipment and plant, and that's what happened in this particular case. Why we're interested in all of this is because the bankrupt guaranteed the liability of Wasu Medical Centre to Aurora, and it was the bankrupt, although he was not liable to pay it, it was the bankrupt that paid the landlord the rent of Wasu Medical Centre. So that's quite important. We're not really concerned with what happened up until HMRC presented a petition against the bankrupt on the 23rd of March 13. So that, if you like, is the trigger date for the authority and for us to be concerned with the payment. Following the presentation of the petition, at this stage, Aurora had not yet provided the equipment, they hadn't even bought it, because under the terms of the lease, initiating payment had to be made, and that was not yet made. All Wasu Medical Centre had paid was effectively the deposit, which was £360, and the payment to initiate the lease was a substantial payment for obvious reasons, because it would then oblige Aurora to purchase the equipment, and they would want to know that at least some large payment towards that had been made. Following the presentation of the petition, the bankrupt paid the initial payment. I forget for a moment how much it is, but it was a substantial sum of money. I think it was around £20,000 or £30,000. And following the presentation of the petition, he made a payment of rent towards the landlord, and another payment, and another payment. So there were 3 payments to the landlord, and there was a large payment to Aurora that was made after the presentation of the petition. The trustee was appointed on the 24th of December 2013, and he argued that these payments were made without any value to the bankrupt. And if I just pause here for a second before we look at the arguments, that appears to be correct because the bankrupt was not the lessee. He was not in occupation of the commercial premises. He had no obligation to pay the lease, the rent under the lease. And also he was not the beneficiary of the equipment because, of course, he did not lease the equipment, although he did indirectly benefit because he guaranteed the payment of the rent, and also he had an indirect interest. He had a direct interest in the company, but he had an indirect interest in the equipment. So that's not Mr. Wasu, that's probably an artist's impression at this stage. The arguments that were made by the trustee were that there was no value to the estate from the perspective of the estate because the payments did not in any way improve or preserve the assets available to creditors. The meaning of value in the provision that we're concerned with means full value or market value from the perspective of the estate. So, for example, a payment of £3,000 would have to provide the estate with the value of £3,000, or the equivalent market value if there's a difference. They also argued that what we are most concerned with is the principle of pari passu, which is the preservation of the assets of the bankrupt for distribution on on an equal basis towards the creditors. And what these transactions did was deprive the creditors of a large sum of money and therefore reduce the amount available to them for distribution. However, the arguments that were made against, the trustee in bankruptcy on behalf of the respondents, which were Aurora in this particular case, and also the landlord, were the word value is not the same as transactions under value. Parliament had not defined what value meant in this particular provision. It simply says for value. Unlike other pieces of legislation, for example, even in the Insolvency Act and other legislative acts, where Parliament has taken the time to define the meaning of value. Here, it was not defined in this particular provision, and it was not appropriate to copy and paste it in effect from another provision dealing with another mischief. With regards to the pari passu point, it was argued to the contrary that this particular provision is concerned not with pari passu, but the protection of innocent third parties and validating transactions with people that did not have notice of the bankruptcy, because obviously you would not have notice of the bankruptcy to qualify for the defence under the provision. The judge held in a really interesting judgment in terms of a policy point of view that what was paramount was the defence of third-party dealings with the bankrupt. That was the most important thing from policy point of view, even though there were compelling interests when it came to creditors and the body of creditors. The judge held that value was to be read literally from the provision, and it was more than an insignificant amount of value, or more than a token gesture. And here he found that the debtor, the bankrupt, plainly did have some value in making the payments that he did, because it allowed the company to operate, and it also allowed the company to obtain the equipment. Now, what you might be saying here is, well, hang on, Iqbal, what was the benefit to the bankrupt? Now, the judge held that the benefit, the value of the incoming value of the payments that were being made did not have to be accrued in favour of the bankrupt. It could be also to a third party, so long as there was value in the payments. And obviously here, it was not argued otherwise, it was agreed, subject to the issue of value being something other than full or market value. It was accepted that there was a value to the third parties in whose favour the payments were made. Now, this is quite an interesting decision, because it appears that there's a bit of a lacuna now in the law, because when it comes to transactions under value, they end at the point of the presentation of the petition. The liability for them ends at that point. So when it comes to payments made by third parties, payments made in favour of third parties, they can be at an undervalue. They don't have to be at market or full value, as long as there is some value in them. So that was an issue that vexed the judge and concerned the counsel for the trustee that made the arguments that, in effect, there would be a get-out clause when it came to payments that were being made following the presentation of a petition. The judge in the end accepted to some extent that was the case, but took the view that the most important thing here was, from a legislative and policy point of view, was protecting the transactions entered into by third parties without notice of the bankrupt's impending bankruptcy. But also, one has to bear in mind that it's not simply a case of making a payment. You have to also establish as the third party and satisfy the judge that you had no notice of the bankruptcy, and that you were also acting in good faith, which is not simply not knowing of the bankruptcy, it's not also being alive to it, not being aware of it, not burying your head in the sand when it comes to it. So it's and also acting in good faith and acting and not having notice of the bankruptcy. So there's at least a good argument that it's not simply a case of making a payment for some value, which is more than nominal. And the authority is perhaps not as bad when it comes to the perspective of creditors as it's been argued before the court. So as I said, the judge held that the disposition must not be gratuitous, but providing there is some value and the other criterion in the provision are met, it would be recognised and validated by the court. As I said, so that would mean, with that construction, that TUVs and preferences would be permitted because, of course, there is no way of challenging a transaction other than TUVs and preferences once a presentation is made, other than to argue that it was made without value to a third party. The key policy principle here is that the court's concerned with protecting the validity of transactions with third parties. Now, the next case that I'm going to move on to is the case of Lyle and Bedborough, which concerns Section 339 transactions at an undervalue. So this is a dispute that concerns the matrimonial home that a couple jointly owned, and it does touch upon, it's not really about, but it certainly does touch upon the meaning of value under Section 3393C. So in contrast with the earlier authority which dealt with third parties, here we're dealing with values, the meaning of value in the context of transactions at an undervalue. And here, of course, Parliament has taken steps to define what value means. The case also concerns the exercise of discretion when it comes to granting relief. As I'll go on to explain, the court has a discretion as to whether or not to make an order once it is satisfied that the transaction at an undervalue exists. The facts of this case are relatively straightforward, but somewhat interesting. We have the bankrupt, we have the matrimonial home, we have the wife. The starting point is that they are joint legal owners of the property, and therefore the beneficial interest is held in equal shares. The wife, luckily for her, receives about 77,000 pounds by way of an inheritance. At this point, I should say that it's the husband that provides for the majority, if not all, of the family income. He has a business that provides for glazing and double glazed windows. The husband is very keen to do up the house. He asks her to put £50,000 to the property. It's more or less accepted by the judge that he pestered the wife into bringing this £50,000 into the property. There is an agreement between them that he will repay her the £50,000, but not a legally enforceable loan, the judge found. This is what was called the 2008 agreement. The wife's case here was that the agreement was a legally binding constructive trust type agreement where he agreed, the bankrupt agreed, to give up his half of the beneficial interest in the property in her favour once she made the £50,000 payment towards the refurbishment of the property. That does sound quite odd. She argued that at the time they were experiencing marital problems, and that was one of the reasons why she wanted to have the financial security of the house in her name. Obviously, the effect of that would be that the half of the property that we're concerned with would disappear from the estate. After, without coming on to what the judge found about that, after the 2008 agreement, which was oral, the husband doesn't do too well in terms of his bills and starts accruing large amounts of debts in favour of HMRC. He starts struggling. He's got to make a payment of about £20,000 to the revenue and gets a bill. He asks his wife to pay this £20,000 bill on the balance of the inheritance that she's got still in her bank account. And there's a conversation between them and a discussion between them as to whether or not she'd be repaid the £20,000 and what this means. Now, it's important to say here that the wife was very concerned about losing this £70,000 inheritance. She was very keen to invest it for the benefit of her children. The judge accepted that all as a fact. So we look at the case from the prism of the facts that the judge found. As a result of this, the wife suggested that she would make the payment to HMRC in return for a new agreement in 2012 at this stage. This was a written agreement whereby 5% all but 5% of the matrimonial home was transferred to the wife. As a result, she held a 95% interest in the property and he held a 5% interest in the property. I just want to pause there for a second, because the very astute amongst you, the ones that have had their morning coffee, speaking of coffee, will be thinking, why on earth are they bringing an argument saying there's a 2008 oral agreement for all of the property being transferred to the wife, and then a 2012 agreement where there's only 5% of it being transferred after 100% was transferred? It doesn't make any sense. You're right. Now, I infer that, or before we move on, the 5% was worth £153,000. So that was the value of the transfer of 45% from the bankrupt to the wife. The reason why these two agreements were contended for by the wife was because on the 25th of November 2014, so just a few days shy, I think 2 weeks shy of the 2-year period, HMRC petitioned for the bankruptcy of the husband. So just within 2 years of the 2012 agreement, they petitioned for bankruptcy. So here the issue was, I don't say that this is why the 2008 agreement was argued, but one can infer from the facts that it made sense to have an alternative case in case the 2012 agreement was set aside as a transaction under value, which on the face of it does appear to be a transaction under value. So it seems that from my inference of the facts that it would be helpful to bring forth another agreement which was conveniently concluded in 2008 outside of the 2-year period as a fallback position. The trustee was appointed on the 4th of August 2015. Now, I think this is a really interesting case because this kind of argument is made very often in my experience. The wife or the grandmother or the mother or somebody always says, oh, actually, it's not the bankrupt that owns the property as per the legal title, it's me. We had an agreement, or there was a trust or something or other, a deed that effectively settled that I would be the beneficial owner. And the question is, what was the consideration? So this is a great authority, if you have a case like that, to look at in terms of the evidence likely to be required by a judge. You know, the real forensic way in which the judge dealt with the evidence and how he weighed it up and how he evaluated it. And also with regards to the steps to take to get from proceedings to an order for sale or transfer at the very end. Because all along the way, each step was contested by the wife. And so it's a good guide to the legal principles that the court would need to apply. The judge, before we move on actually, the judge rejected the 2008 agreement. He accepted that there was some sort of conversation and some sort of, in quotation marks, agreement, but it was to the effect that the husband would transfer his interest in the property when asked to do so legally. So it was, in effect, it was an agreement to do something when required rather than an actual binding agreement giving rise to a constructive trust. The reason for that was that the evidence wasn't quite there. There was not a clear demonstration of a common intention in the evidence. So the judge had some room to say, well, actually, there's not a common intention without finding that anybody was dishonest or making it up. And as a result, he found that the question before him was whether or not the 2012 agreement was a valid agreement. Long story short, he found that it wasn't a valid agreement because the consideration that the wife gave was £20,000 in return for £153,000. It was also argued that she gave the consideration £50,000 in addition to that, and also the forbearance of divorce. So she agreed not to divorce him. The judge rejected the third. As a matter of fact, he didn't find that there was such a forbearance, that there was realistically going to be a divorce, and she forbeared on divorcing him because the deed doesn't really mention it. He accepted the £50,000 payment was made, but he didn't accept that that was what gave rise to the agreement. He accepted that the £20,000 was the consideration for the agreement to transfer the 45% interest of the husband. Obviously, that on the face of it is clearly significantly less than the value that the husband gave to the wife. So the argument that was made then by the wife's counsel was that the value was 50,000 plus 20,000 plus foregoing divorce. And it was argued that the outgoing value should be looked at from the debtor's point of view. And this is a really interesting little argument here, because that's well known. It's looked at from the estate's perspective, of course. And the argument here was that means literally. So we look at it from the debtor's point of view. The debtor is desperately trying to avoid a divorce. And that means a lot more to him than it would mean to me or Mr. Justice Moran or Morgan or whoever. So we look at it from his point of view. The court roundly rejected that. It is from the debtor's perspective, but it's an objective perspective. It's not literally based on his subjective feelings. The judge held that on his assessment, the incoming value was significantly less and was not in any way comparable to the outgoing value to the estate. Yeah, as I've already said, he said that the perspective of value was an objective one, looking at what the debtor receives, not what the debtor feels about what he receives. Arguments then moved on after having lost a substantive point as to whether or not the judge should exercise his discretion to make an order. The arguments that were made before the judge was, first of all, the judge, she's being put in a much more unfair position now than if she had divorced him in 2012. Of course, the whole point of the wife's case was that I only entered into this agreement because if I got the property and got the financial security that I wanted, I will not divorce him. And effectively, you're stripping me of the consideration that I received in return for not divorcing him. Quite apart from the fact that the judge did not accept that as a matter of fact. In any event, it was argued at this stage in the exercise of judge's discretion that she would have been better off if she had divorced him in 2012. And it would seem unfair then to penalise her now because she didn't divorce him. Of course, if she had divorced him, her interest in the property would be unimpeachable if she had received 100% of it in a divorce, a contested divorce, as opposed to a deed of transfer in the way that it was done. Also, it was argued, and I think this is quite a common thing that we have to deal with, that it was very close to the 2-year period. It was just on the cusp. And it's really unfair that if the agreement was made a few days earlier, or the petition was presented a few days later, that the wife would be all clear. I should say at this stage that the trustee also brought an alternative case for a declaration that she defrauded the creditors. That was not determined. It was effectively irrelevant. So that we're only dealing with a 2-year time limit here. The judge, this is a judgment worth reading, I think, when it comes to certainly at this point of the exercise of the judge's discretion, because if I just narrate what arguments were made and what the judge found, one could easily think that the decision was harsh and probably not what we would expect from the judge. So it's a good one from that perspective, because a lot of the arguments that were made by the wife, which I'll come on to when it comes to children, are the kinds of arguments that we would expect to receive from either debtors or third parties with a shared interest with the debtor, if we're acting for creditors. So firstly, the judge found that, the judge said that he had a balancing exercise to perform, but it was one which decidedly favoured the creditors. The creditors were supposed to prevail in any contest between the family or the interests of the wife or the children in exercising his discretion not to make an order, because Parliament had intended there to be an order if there was a transaction at an undervalue, notwithstanding the fact that he had a residual discretion to not make an order. That would only be exercised in wholly exceptional circumstances. And here, there's nothing exceptional. When it came to the divorce, the judge more or less said that that's hard luck, or if you like, the benefit of hindsight. Yes, it appears to be somewhat tough for the wife, but it's equally tough for the creditors if I apply it in her favour and exercise discretion not to make the order. So why should the creditors suffer? Somebody's got to suffer the bad luck. So it's best just to keep it where it is with regards to the wife. On the subject of the 2 years, I thought that would exercise the judge's mind to some extent, but it didn't really. The judge took the view that Parliament had established a bright line rule, and basically you're either within it or you're not. And he took the view that it was really immaterial, that it was very, very close to the 2-year line. And I think that's a good authority for that particular point, because that does come up quite a lot, certainly in correspondence or pre-action stage, negotiation, and sometimes in court as well. Right. Finally, then they contested the issue of remedy. The argument was twofold. Firstly, that the remedy should be not that the transaction is reversed and the parties are put back in the position that they were pre-2012, but that the wife should be able to buy out the trustee in bankruptcy, which, on the face of it, fine. However, only at the 2012 prices. I have really struggled to understand the logic of this argument, if I'm absolutely honest with you, but I think the argument was along the lines that because this transaction took place in 2012, that's when the deed was done that is being criticised by the court and been set aside. It's at that stage we've got to go back in time and allow her to buy out and undo the transaction in 2012. I mean, the argument was that to do so now would provide a windfall to the trustee because the property has gone up in value. I mean, I struggle to understand the logic of that argument, but we'll come on to what the judge said. The judge rejected that. He said that the relief has to be restorative. That's the purpose of the legislation and the purpose of setting aside a transaction under value. And the restoration here would be to put the bankrupt estate in the position it was before this transaction at an undervalue took place. So if you like, you cut out the transfer in favour of the wife in 2012 and see what's there. So what was there before was a 50-50 shared beneficial interest between the husband and wife. With regards to the 2012 prices, the judge did not accept that there was a windfall. I mean, as a matter of logic, it's difficult to see how we wouldn't. Because of course, if that transaction did not take place, as of the presentation of the petition, the property value would be as of the date of the presentation of the petition, at the date of the hearing, as of today, not in 2012. There's no reason why prices should be frozen to 2012. However, restoring the parties to their previous position meant that the wife should recoup her £20,000 plus interest, because of course that was the consideration that she gave under value for this transaction. There's a really sort of short but interesting reason why the judge found that the £50,000 was not recoverable by the wife, which I thought was a bit harsh. But long short of it was that she wasn't entitled to an equitable account of the £50,000 because they were married and it was a joint enterprise and parties were not expecting there to be a strict legal arrangement as to money going in and out of the marriage when it came to paying for a refurbishment of the property. Finally then, the judge had to decide whether or not he should order a possession and a sale of the property. An important note here that, so this is a section 14 trust of land type of application, type of discretion, but the court reminded us all that it's section 335A of the Insolvency Act applies, not section 15 of Talata. And the judge considered the factors in section 335A. Now in section 335A, it provides that if the application for possession or sale is brought 1 year after the making of a bankruptcy order, then the presumption is that the creditor's interests will prevail. And there were some brilliant arguments, I thought, made against an order for possession and sale in a short period of time by the wife. The first one, which I thought was a really good one, and I thought could swing it for the wife, she said her children were in a local school. They had just about 2 years to go, and it would be very difficult to find alternative accommodation in the local area for them, and it would be hugely disruptive to their education. The second argument that she made was that she was going to be very, very unlikely to afford a comparable property in the local market with the money that she had available, of course, plus or including her 50% interest in the property. And she also made the point that the property as it was very cramped. So it realistically could not be any smaller than what the property was at this stage. Thirdly, I think the argument was made obliquely because it's not quite referred to as the response argument, but the judge considered the factor of the coronavirus. Because at the moment, of course, it's very difficult to go and look at properties, meet people, it's the conveyancing market has slowed down and so on and so forth. So in conclusion, Judge, it was argued, can you delay this? Can you defer the making of a possession order and an order for sale for 2 years to allow for the coronavirus to disappear? Of course, in 2 years' time, we'll probably be in the 58th lockdown. So that's not really a runner. But in terms of the other two arguments, at least, the children will have left school. I would be in a position to buy a local property, or I wouldn't need one. And it would be much more fair for all concerned that the order for possession and sale was made in 2 years' time. In addition, just to the icing on the cake, we also have, I think it was the mother, forgive me if I've got the wrong relative, but there was a relative that was unwell, had a medical condition, and they lived in the property. So the whole cock caboodle being argued here. So I thought, the judge has got to say, I'll defer this for a couple of years. He'd have to be pretty hard-nosed, having rejected the £50,000 as a loan, having rejected the 2012 agreement and the consideration the wife contended for it, having rejected the remedy arguments that were made in terms of reversing transaction. I thought he might give the wife something. Instinctively, as barrister, you always think that the judge wants to give a crumb of comfort to the losing party. But not on this occasion. The judge found that there were no exceptional circumstances. Children's education was not particularly exceptional. This is the run-of-the-mill argument. This is the thing that everybody has to experience when it comes to giving up possession of property. When it came to the sick relative or the relative with a medical condition, the judge held that that itself was not exceptional, although he did suggest he did give a nod to what might be exceptional. He said it's not like, for example, that the property had been adapted for use or had a significant amount of work done on it for the particular use of a disabled person. So I inferred from that that might have made a difference. It was just simply the case that she's living with us and she's not well. The judge accepted that the coronavirus made looking for alternative properties and accommodation difficult at this stage. He also accepted that the wife had an interest in the property as well. He had recognised that she had 50% interest in the property, and he would be making an order in terms of period after hearing submissions on the point. So he doesn't tell us what order was made, but he does refer to the fact that 6 months it should be in months in terms of anything longer than that. And he referred to an authority where the judge held that 6 months was really a very generous period of time. So moving on, we've got you'll be helpful. You might want to know that these authorities are a lot quicker because they're not quite as interesting in terms of facts and not quite interesting in terms of the learning points that we've got from them. The next one is Lau Yu and Tiffany. This is a case that takes us out from the dark and rainy suburbs of London to the glitzy, glamorous skyscrapers of Hong Kong. Lau Yu and Tiffany is a case that concerns a recognition order of foreign marriage proceedings under the cross-border and insolvency regulations. So in here, in effect, there were bankruptcy proceedings in Hong Kong, and there was an application made in the High Court of England and Wales to recognise those proceedings as the main proceedings. But what we're interested here is, or what this case is about, is the service of that application abroad, the service of that application in Hong Kong on the debtor in Hong Kong, and whether or not that service, if it was not good service, could be retrospectively validated. The facts are very, very straightforward. There was a debtor, he was in Hong Kong, he was subject to insolvency proceedings, I assume personal insolvency proceedings, subject to the jurisdiction of the Hong Kong court. I think it's the Special Administrative Region Court, Hong Kong Court. Over here in London, in the High Court, there was an application made to recognise those proceedings as the main proceedings, and they were served by courier in advance, or at the time of the application, they were served by courier on the debtor in Hong Kong where he lived. There we are. Now, this whole case, frightfully dull, I confess, as service cases often are, but it really is about the interpretation of Schedule 2 of the 2006 regulations, in particular regulations 22.2 and 22.3. And I'll just give you a moment to read them. While you do that, right, so it concerns the interpretation of these two provisions. So starting point is service must be effected by delivering documents to a person's address, and that's then specified and qualified by the subsequent provisions of this regulation. So the proper address means any address of which you have been notified within England and Wales, and there are some sub-provisions which I've not bothered quoting, but in effect what it means is the service has to be in England and Wales, in short. Obviously here the service was in Hong Kong, so that was the issue. By the time it gets to court, that's the skeleton argument of one of the barristers. I'll manage to find a picture of that. The argument is all about whether or not this was good service in Hong Kong. Was it mandatory that service be in the UK? And if forgive me, England and Wales. And if it had to be in England and Wales, do you have to make an application for directions in advance of service, or could you validate the service after the fact, which was what had happened here? Now these are the this is the decision made by the judge. If service cannot be, if you cannot serve at a proper address in England and Wales, you need to obtain directions in advance. So that's the answer to that question. However, you could obtain retrospective permission as you could under the CPR. So it's not simply a case of insolvency proceedings having a different rule. It's a similar or the same idea and principle as the CPR and serving people outside the jurisdiction. However, the judge, so in this particular case, on the appeal from the registrar, the issue was not argued over whether or not there was a reason for not obtaining directions in advance of service. It was a square point, a simple point as to whether or not it was the registrar could permit the service retrospectively, could validate it, forgive me, retrospectively. So had they lost on that, the rest of the appeal just fell away. But in deciding that point, the judge did make reference to the fact that while retrospective permission can be obtained as per the CPR, he did say you have to have sufficient reasons for a failure to obtain directions in advance. And also, the second condition was that you've got sufficient reasons, number one, and also that the documents had been received by the receiving party in good time and were able to act on them without detriment. Now, in this particular case, the debtor not only received the documents, it baffles me why this argument was made, but he also turned up to court and argued about the application and instructed counsel, did a statement. So it's difficult to see why you're going to argue about the validity of service when you actually, the whole point of service is to tell you about an application and you're in court arguing about it. Obiter, the judge also held, and this is obiter because it was not necessary for the determination of the appeal. In Schedule 2 of the regulations, at paragraph 57, if the failure to serve correctly, if it could not be retrospectively validated, it was not an irregularity which could be remedied by the saving provisions or the saving power of the court, which is to remedy any defects, any formal defects or irregularities. So that was the alternative argument made by the trustee. The argument was, well, look, if this is not possible to retrospectively validate this service in Hong Kong, then it's a formal defect. And the judge, it's obiter, but the judge said, I don't think that would be right. It's not a formal defect. So that's quite interesting. And also obiter, the judge said that if I was wrong on the retrospective validation point, I would have found that by contesting the merits of the application to make the recognition order, that application, by contesting the merits of it, he submitted to the jurisdiction of the courts of England and Wales in any event. So the poor service point wouldn't get him very far. Finally, we're going to deal with the case of Mortgage Industries in Mittal. That is actually not an artist's impression, that is Mr. Mittal. Just point of note here, this is not the famous Mr. Mittal that we all have heard of, that we've spammed for investment advice and payment into our trust funds. This is his brother. This is a bankruptcy petition. You might think, well, why on earth is this a reported decision? Why do I care about a single bankruptcy petition? Well, because it's for the sum of £139,786,656.43. Now, I'm not going to lie, I was mildly gratified seeing that somebody had taken the great care and effort to put the 43 pence in, because I've always argued with opposing counsel when I deal with interest that the 43 pence is what makes a pound, which will make £100 and £1,000 and the £139 million in the end. So I'm really glad that somebody went to that effort to calculate the pence. This case is about a couple of things, but the most important one is set-off. The law of set-off as it relates to bankruptcy petitions, as it relates to statutory demands. If you have a set-off type argument ever for or against, I think this is a good authority to go to because it gives you all of the arguments and the authorities on the particular point. Whether or not there was a cross-claim against the petitioning creditor, and whether the errors in the alleged errors in the petition were sufficient to dismiss it or to order a amendment and reservice of the petition. Finally, if I'm wrong in all of that, said the debtor, can you give me a reasonable time to pay? The facts are very straightforward. there was an arbitration award made for $120-something million against a company called GKIL. GKIL's debts were guaranteed by the debtor and another party. The other party is not particularly relevant, but I'm going to come back to the other party at some point. But in essence, the debtor guaranteed the debts of GKIL. As a result, proceedings were issued against the debtor in England and Wales, and judgment was obtained for the judgment sum, which is what the petition was, what the statute demand, forgive me, was based on. We need to know two things. Firstly, the first petition was presented, but then it was withdrawn on the 15th of October 2019. That resulted in a costs order in favour of the debtor against the creditor. The sum of costs payable was £66,000. They initially agreed the wording of the order. I don't know whether it was a Tomlin order or what it was, but in essence, they did agree the wording payable in 14 days. This will have a significance. The judge declined to make the order as drawn by the parties and made his own order, which was simply the cost to be paid in the sum of £66,000, no time to pay. As night follows day, when you've got £139 million at stake, a second petition was presented on the 29th of November 2019. In that petition, the £66,000 was set off. So they deducted the petition debt, the judgment debt, forgive me, by setting off the sum of £66,000, not having paid it. I'm just going to quickly calculate how much was left over for payment by the debtor. A lot. I'm no mathematician, but it seems to me it's small beer in the scheme of things. But nevertheless, it was argued on behalf of the debtor that the creditor had breached the compromise agreement. Now, I thought this argument was incredible that this was made. But in essence, what they had entered into was a compromise agreement for a lower sum of money, providing that certain conditions were met. For example, payment was made and so on and so forth. This is very, very standard. This happens all the time. And there's always a provision in the agreement that if you do not stick to the payment plan, then the full sum that was previously owed is owed, and a judgment can be obtained by the creditor in that amount. Now, the provisions of the compromise agreement weren't followed, so the debtor was in default of the agreement, so it was really irrelevant what the figure was in the compromise agreement. It was immaterial because it did not apply anymore. But it was first argued that this was the sum due, so the petition debt was wrong. That was dismissed by the judge, I thought, quite obviously as without merit. So that's a terrible argument, and I have no idea why that was made. Secondly, it was argued that the court has the power under Section 266 to dismiss or stay a petition, which of course it does, for a contravention of the rules or for any other reason. What was the any other reason in this particular case? Firstly, because the judgment, the costs order of £66,000 was not paid, and it would be wrong to bankrupt the petition without satisfaction of that costs order. Secondly, there was no mutuality between the two debts. This argument was really along the lines as follows. The judgment debt was joint and severally liable, was a liability that was joint and several between the debtor and another party. The costs order was something that only the debtor had in his favour. So the two debts are different. They're not, there's no mutuality between them. And as a result, one cannot be set off from the other. And also, although it's not in the order, the parties had agreed payment within 14 days, and it was quite wrong that payment had not been made within 14 days. The judge held that set-off is a very complicated area of law, which is what judges say after they've been shown about 19 authorities that say slightly different things. But the question for him was whether or not the debts are closely connected, and clearly they were. They arose out of the exact same liability, which was the arbitrary award and the enforcement of it. The judge found that the debts were so closely connected that it would be unjust to require the creditor to make a payment of the costs order and then to require him to amend and reserve a petition and then have a hearing on the balance of the substantial balance of the debt that was still owed. Obviously, reading between the lines, it seems to me that the debtor was really just trying to get an adjournment and applying for more time. And of course, he had actually applied for an adjournment, which was refused by the judge at the very beginning of the hearing. The judge also held, because set-off is a very complicated area of law, we could probably do a whole week on the law of set-off itself. But the judge said, look, the point here is that there is no authority on this point that you have to pay the costs order or the costs arising out of the first aborted petition as a condition of bringing the second petition. There is no authority on this at all. That's quite important because, for example, in civil proceedings, you can't bring a second claim arising out of the same cause of action without paying the costs of the first, without the consent of the party that you're suing or the permission of the court. So in contrast to that, insolvency proceedings do not have a similar provision. So the judge said, well, if I'm going to be asked to stay a petition on the basis that the previous cost order has not been made, I'd want an authority, and there is no authority. Finally, so those arguments were dismissed. The next argument was that the petition is defective, and the only argument that really is worth mentioning is that, and this is very common, interest was added on top of the sum in the statutory demand. Now, I remind everyone, so this was actually the reason why, one of the reasons why my petition, which I mentioned earlier on last week with the commercial tenant, was adjourned with an order for amendment and reservice, because in that one they had also petitioned for a sum larger than the statutory demand, which you can't do under the practice direction. It says very clearly it must be the same sum. Anyway, in this particular case, what they've done is, and this is very common, in the statutory demand, they'd said interest is accruing and continues to accrue at the rate of blah, 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 blah. And then in the petition, they had added and compounded that interest and put it in the petition. So the difference between the two was only the interest that had accrued in between. Now, as far as I'm aware, this is the only time that this issue has particularly been dealt with by a judge. And there were some arguments made about whether or not you could do this, quite contrary to what the practice direction says, but whether or not this also applies to putting the rate of interest and simply calculating it for the purpose of the petition. The judge found that the inclusion of post-demand interest was a defect. So there's a rule on that. And he also found that he could cure it under the saving power that he had to cure formal defects and irregularities under Rule 12.64. And that's how he was going to deal with it. He was going to adjourn the petition, he was going to dismiss the petition. Since the last slide, that's the interest that's accrued on that judgment debt. Now, the last argument that was made, which is sort of, a Hail Mary almost, was the time to pay. He argued that the petition should at least then, the hearing of it should be at least adjourned for about 17 to 18 weeks to allow him to pay it in full. He argued that the co-guarantor, so I remember I said to you that the guarantee of the company's debts was between the debtor and another party. This is the other party. And the co-guarantor was due, he said in a statement, $350 million US from a mediation in Nigeria that was taking place. The mediation was ongoing. I thought this is a pretty interesting, very, very good argument, somewhat compelling. The debtor said, look, under the terms of the potential settlement here, I am going to benefit by way of a dividend to the tune of tens of millions of dollars, but only on the condition that I'm not bankrupt. So the judge is being told, if you bankrupt me, there'll probably be nothing in the pot for the creditor and the creditors, of course, the class remedy. But if you adjourn this, it's highly likely that I'll be able to make a substantial amount of payment towards the petition debt. But if not, I will still benefit by the tens of millions of dollars that would be paid to me as a result of the settlement. And as a result, he sought an adjournment of 4 to 5 months. Now, the court, first of all, started with its jurisdiction. The court has a wide, unfettered jurisdiction when it came to case management of the hearing of petitions. He could grant an adjournment, but there were strings attached. The court reminded us all that, first of all, we need a reasonable prospect of full payment. And that's important because a lot of the time people say, well, I might get this and I might get that. But the test is whether or not there's a reasonable prospect of full payment, whether it's within a reasonable period of time, and whether the evidence is credible. Now, just pausing here for a second and moving off Mittal for a moment and going back to my first couple of slides, it might be that when you're talking about allowing the debtor to enter into the debt respite scheme, that you might want to provide some evidence about the reasonable period in which the payment would be made, even under the scheme. It might be that you want to explain exactly what will happen under the scheme, because depending on the arguments that are made obviously against you, it could be said that, oh, you're just saying this, you're not going to enter into a scheme, and the creditors will be prejudiced by the delay. So I think it's worth thinking about this, because in effect, although you're asking for the benefit of impending legislation, which is coming into force on the 4th of May, in effect, it could be said that you're also arguing for an adjournment to allow you to enter a scheme that would allow for some form of payment or repayment over a period of time. So coming back to Mittal, the judge found that in contrast to what he has to, the test that he has to apply in the exercise of discretion, here it was not being said that there was going to be a full payment of the petition debt. That's the starting point. There's a difference between tens of millions of dollars and $100+ million. And what's being said here is, at best, there will be a large sum of money, but the assumption in the evidence is that the petitioning creditor will accept it, will have to accept it or will accept it. And the judge didn't attach much weight to that. Obviously, if they were going to accept it, they would have agreed to the adjournment themselves. The second point here is just on this point of the evidence, that the debtor, I thought his evidence was very carefully couched. He said things like, may settlement, the settlement may result in, likely to be. It's the kind of lawyery language that we would use as lawyers when drafting a statement. The judge made the point that credible evidence of something happening is not the same as saying it's likely to happen. So he drew a distinction there between the evidence that was provided, which was on a likelihood basis, and the evidence that he wanted, which was on a credible evidence of something happening basis. So I think that's worth thinking about when if you're pursuing this kind of time to pay argument. The evidence has to be pretty solid as to payment being made. That's the next slide, and that's the resultant interest that we've accrued on Mittal for the last 20 minutes, probably another $130 gazillion. So conclusions. Firstly, the authorities that I've looked at, certainly the first two, demonstrate that there is a greater emphasis on the creditor interests when it comes to weighing up and balancing the interests of third parties, debtors and creditors. Of course, the exception to that is third party protection for those that are affected by transactions without notice of the bankruptcy and act in good faith and receive some value. Also, it's worth bearing in mind that adjournments at this stage, on the one case that we've got, if you're going to be running an argument that I want an adjournment because of this, that, the other problem with the petition, or because I want time to pay, it has to be evidence-based. Just pausing here for a second, it's always a difficult one as an advocate to predict or advise on whether or not the judge will grant an adjournment. Sometimes you very easily get an adjournment, and sometimes it's, you don't get one and you're quite surprised even though you think you've got good grounds. There's not been many petitions that I think have been heard in the last 12 months. On the few that I've had the luxury of dealing with, the courts have been ready to grant an adjournment if you can give them a reason. So in my case, I managed to persuade the court to make the order to amend and reserve on the basis that there was a mistake with regards to the difference between statutory demand and the petition, and also, perhaps more critically, that there was a failure to provide a certificate of continuing debt, schoolboy error, and also there was a failure to provide a certificate of searches. I think that if you can point to some defect like that, you're more likely to get an adjournment. But otherwise, if you're going to argue time to pay, you want good evidence to that effect. I've just addressed procedural defects just there. And also be aware of the debt respite scheme, whether you're out for creditors or debtors. Both sides, debtors and creditors, will need advice in the scheme. My strong recommendation is that you have a look at the guidance and you brush up on it as opposed to going through the regulations, which are quite cautious. But the guidance is brilliant and it's well worth a read. Thank you very much.
Great, thank you very much, Iqbal. There's a few questions come in while you've been talking, and we'll go through those now. First couple of questions are on the debt respite scheme. So the first question is that the scheme covers some business debts, but goes on to state that they do not qualify if the debt relates only to the business. Does this mean that a sole trader who orders goods to use for the business, could the breathing space operate in respect of those debts? What do you think?
That's a really good question. So on the face of it, it may not apply to that particular scenario, but this is the analogy that I would draw. In my case, the commercial tenant had the property for the purposes of a business, but his liability to pay the debt was a personal liability. So if there can be an argument made that the debt is a personal liability and it's not a business debt, then it could possibly fall within the scheme, but otherwise it would be excluded. The way that the scheme works is you basically add up your debts and you say to the agent, these are my debts and I want part of the scheme. And it's for the agent to then decide whether or not they fall within the scheme or not. So that would be the way that it would be dealt with.
And I think the guidance says that business debts do not qualify if the debt only relates to the business and the debtor is VAT registered or is a partner in a business with someone else. So that suggests that if it's a sole trader who's not VAT registered, then they're not going to be excluded debts, they're going to be within it. And I think also credit cards are within the scope of the breathing space debts. So if the sole trader's in trouble, they're probably using credit cards to fund their business purchases, and the personal credit cards going to fall within the breathing space. So I think it's only going to be strict business debts where the debtor is VAT registered or in a partnership where they're going to be excluded.
Yeah, I think that's a really good point, Mark, because for example, you might have broadband solely for the use of the business, but it's being paid for out of an overdraft that you have in your personal account, in your personal name. So the debt as regards the overdraft would qualify, even though the particular payment for the broadband wouldn't. So it depends on how you look at it and how you argue, but it seems to me, as long as you have a personal liability to pay the debt, you probably would qualify unless you're excluded. And the qualifying debts, actually, the guidance says it will be qualifying unless it's specifically excluded. So it's worth looking at it quite carefully.
Second question on that is, does enforcement action include pre-legal collections, for example, in-house credit control or general legal pre-action work, such as letters before action?
Oh, that's a good question. And I'm not sure what the answer to that is, to be honest.
All right. Well, I've had a look.
But I can tell you that the main object of the scheme is to obtain a stay and cessation of enforcement, legal enforcement.
I've had the benefit of having a look at this while you've been talking, and it does seem that once a debtor has breathing space, it is expected that creditors will not chase the debts anymore, and they should not contact the debtor in relation to the debt. The creditor can contact the debtor's debt advisor, who will have been involved, as you said, as the gatekeeper on obtaining the breathing space. But the creditor should not contact the debtor otherwise, should not send LBAs, should not send collection letters. So the idea of the scheme is that they won't send that ongoing correspondence. That's the idea. So next question is on the transaction and undervalue case for you.
Yes.
And the question is, on the basis that the judge found there had been an agreement to transfer back in 2008, as opposed to a constructive trust, could there have been a form of estoppel argument available to her? So if there had been an agreement to transfer in 2008 rather than a constructive trust?
Well, that's an interesting question. I mean, the starting point on the case is that, bearing in mind the judge didn't consider or determine that there was any intention to defraud creditors. The first point is that if there was a 2008 agreement that was legally enforceable and binding that gave rise to, for example, a constructive trust, it would be outside the 2-year period, so that they would win on that point itself. So we wouldn't need to bother with anything else. And I infer this from, I'm not saying for a moment that they concocted this, and the judge of course found as a fact that this did happen. So but that's why I infer this argument was made about the earlier oral agreement, which was inconsistent with the latter written agreement, and also would to some extent discredit the 2008 oral agreement. But it seemed to me the argument had to be made because they had no way of escaping the 2-year period in which the transaction was caught. So that's I think the answer to that. If it was a binding agreement, it wouldn't fall within the 2-year period and it'd be home and dry.
Okay. Last question for you. Could you confirm the decision on statutory demands and the debt, including an increase due to default interest? So that's just confirming what the decision is in relation to the statutory demands and the debt increasing due to default interest. So I think what you said is that the value of the debt must be fixed as at the date of the statutory demands.
Sorry.
Yes.
Yeah. Sorry, I didn't quite understand the question. So yes, yeah. The starting point is the practice direction. The practice direction clearly says, paragraph 12.2.2, I think, that the bankruptcy petition must be based on the same debt as provided for in the statutory demand. That's the starting point. So there is no kind of scope for adding in interest or adding in this or that. But that's very common. People very commonly do that. The judge found in the particular case that I went through that that was a defect. So if you did that, you are presenting a defective petition, and it may be open to the judge to allow you to proceed by regularizing the position and treating that as a formal defect. But of course, you know, you might not have that with the judge. A judge might accept, as the judge I think did in my case, that that was a serious defect that required an amended petition to be filed, served and re-verified. So it's a big risk, and I don't think there's any point in adding it because of course you're either above the 5,000 statutory limit or you're not. So if you're above it, what difference does it make that you've added on a bit of interest for a couple of months?
But I think that's the important point, isn't it? If you've got £4,900 as at the date of the statutory demand, you can't make up the extra £100 with interest between the date of the demand and the petition.
Yes, quite right. Yes, you should wait a couple of months for the interest to accrue before you serve the stat demand. Great.
On behalf of myself, the other members of the St Phillips Insolvency and Restructuring team and all the attendees today, I'd like to thank Iqbal for his presentation. Thank you everyone for attending this, the second of our week-long webinars during Insolvency Week. Tomorrow, myself, I'll be talking about Brexit and its impact on cross-border insolvency, joined by Kirsty White, who will be talking about directors' disqualification. And that webinar will be chaired by Rob Mundy. And then on Thursday, Ali Tabari will be talking about administration changes and trends, and Raghav Dravedi talking about recent cases on directors' liability, again chaired by Rob Mundy. And on Friday, we'll have our plenary Zoom meeting where you can ask us any questions. And of course, we get to see you as well as you seeing us, for what will hopefully be a convivial meeting to finish off this Insolvency Week. So enjoy the rest of your day, and I look forward to seeing you all again soon. Goodbye.
Bye-bye.